Welcome to the Animal Law Podcast. This is Marianne Sullivan. Today I'll be speaking once again to Delcianna Winders, and she'll be updating us about one issue she last spoke to us about 2 years ago on episode 21, and another issue she spoke to us even longer ago on episode 15. Both of them, of course, have to do with the Animal Welfare Act, and believe me, there is no one on the planet who knows more about the Animal Welfare Act and how it's enforced, or kind of how it's not enforced very well, than Delcy. And first, the first case we're going to be discussing is the latest on the blackout, which you may have heard of because it's been a big issue. They blacked out all of the Animal Welfare Act inspection and compliance records on the USDA website where they had been recorded for many years. And we'll see that some records have been restored, but not in the way that anybody would need them to be. So the litigation continues. There has, in fact, been a very recent decision in one of the cases. It's not resolved yet, but it's an important update. And second, we'll be discussing the USDA's very recent proposal to resolve its completely ridiculous practice of rubber stamping license renewals regardless of the compliance history of the licensed facility. Again, there has been some progress, but not nearly enough, and that's an ongoing saga. So before we get to the interview, which I think you're really going to want to know about, I'd like to quickly ask for your support in helping us keep Our Hen House, which produces the Animal Law Podcast, along with the Our Hen House podcast, to keep it going. And if you can help out, please go to ourhenhouse.org/donate. And please do it now if you can, because we really could use the help. You can join our special band of supporters whom we call our flock, or if you're not up to that, you can just make whatever donation you can afford and are comfortable with, and we would really appreciate it. The only way to keep this podcast and animal-friendly media in general going is for the people who care about animals to support it. And in this case, I hope that will include Our Hen House and the Animal Law Podcast. And now to Delcy Winders, who, she's been on the podcast a number of times. I've known her since she was in law school. She's an amazing lawyer. She has made amazing accomplishments for animals and really devoted her life to this. She was the first animal law fellow at Harvard. She has, way back in law school, she was writing law journal articles about animal law. She is the real deal. Right now, she is the director of captive animal law enforcement for PETA. And as such, she is one of the world's leading experts on the Animal Welfare Act. And I think you're going to find this very insightful, very important, and you're just not going to want to miss this interview. Welcome back to the Animal Law Podcast, Delcy.
Thank you, Marianne. It's very nice to be back.
It's really nice to have you back, and it's really nice to get updated on two huge Animal Welfare Act related cases that you have been on the podcast to talk about before, and there are updates in both, though neither is complete. Does anything ever get finished in the law?
Yeah.
I don't know.
I mean, I've only been working like a decade on these ones, so we'll see.
Yeah, we need to give it time.
Yes.
All right. So first, we're going to talk about the situation, which a lot of people are familiar with, about the blackout on the USDA's website about information related to the Animal Welfare Act. And I strongly suggest to people that they listen to episode 21, which we recorded back in March of 2017. It seems hard to believe it was that long ago.
Feels like a decade, but
yeah,
it wasn't.
It does. Well, basically, it was when the Trump administration began, and it does really feel like a decade since then for so many different reasons, including the Animal Welfare Act blackout. So you joined us then to talk about this situation. And even if you haven't listened to that episode, though, or for those who don't want to, Delcy, can you just kind of tell us briefly about how this all started? What did the USDA start doing back in 2017 that it had not done before that everyone was so upset about?
So on February 3rd, 2017, so very shortly after Trump took office, the USDA abruptly and with virtually no explanation deleted from its website thousands of records related to enforcement of the Animal Welfare Act that had been posted online routinely for many years.
One thing I didn't understand at the time, which you explained to me, but which I want to reiterate, I just wasn't aware that there were records that automatically get posted pursuant to the Freedom of Information Act, rather than people having to file a request and ask for them. And can you just tell us, like, what sort of, and you assert, I think, that these are those kinds of records, and the USDA had treated them like those kinds of records because they just posted them automatically without being asked to. So you could just tell us a little bit about those kinds of records and why these fit into them?
Yeah, so most people think of the Freedom of Information Act, or FOIA, as a law that allows you to request records and get them from the government, and it is absolutely that. But less known is the fact that FOIA, and provisions that are often referred to as eFOIA or electronic FOIA, also requires proactive or affirmative disclosures. It requires federal government agencies to post records on their website, not necessarily in response to a particular request. And what they need to post, among other things, are records that are frequently requested. And the agency itself recognized, and its FOIA logs bear out, that the types of records that were deleted in February 2017 were absolutely records that were frequently requested and were, in fact, the most frequently requested records.
And they're allowed to redact them, right, for privacy? Is that right?
They are, and they did. They always did. I mean, things like signatures, birthdays, social security numbers, phone numbers, those things have always been redacted, and no one's had a problem with that.
So you call them the eFOIA class of documents. I noticed that in the district court decision, the judge called them the reading room provisions. Are they the same things? I like the name, the reading room provision.
Doesn't it sound pleasant?
Yeah.
I want to go there. Yeah, they are the same thing. And it's the way a lot of agencies do this is it's now a virtual reading room where they'll post these records online. So there's a one-stop shop to access them.
So before we get to the lawsuit, let's just briefly talk about why these records, the ones that were up there and then disappeared, why they're important. What are they, and what use are they to people like you or people at PETA, activists who care about animals, just anybody who is interested in these issues? What documents are they, and why are they important?
So they are 3 categories of documents, all of which relate to the U.S. Department of Agriculture's implementation and enforcement of the Animal Welfare Act. And the Animal Welfare Act is our nation's most important animal protection law. It's intended to ensure the humane care and treatment of animals used in laboratories, in the wholesale pet trade, and for exhibition. And the categories of records are 1, inspection reports. So when the USDA goes out and inspects for compliance with minimum animal welfare standards, they generate a report that shows any violations. So that's the first category. The second category of records are enforcement actions for facilities that have chronically violated the law and have faced enforcement. Those actions were posted. The third category are annual reports for research facilities, which show the number of animals used for research, the types of animals, importantly, the number of animals who were subjected to experiments that involved unmitigated pain or distress, and the reasons for subjecting animals to unmitigated pain or distress.
And how do activists use these records?
Yes. So, sorry, the second part of your question, why are these important?
No, I frequently ask 12-part questions, so just stay on your toes, Delcy.
Yeah. I'll do my best. So these records are really important for 2 main reasons. 1, so that we can monitor whether the USDA is doing its job in enforcing the Animal Welfare Act. And that's a particular concern because for decades, the USDA's own Office of Inspector General has said over and over again in formal audit reports, the USDA is not adequately enforcing the Animal Welfare Act. So we need to vigilantly monitor the USDA's enforcement of this statute. 2, we need to be able to know what's going on at these facilities, whether it's a circus, a roadside zoo, a laboratory, a puppy mill, so that when the USDA doesn't do its job, we can step in and get help to these animals. those are the key things. There's a lot that goes along with that. Holding facilities accountable in addition to the USDA. But the bottom line is holding the government accountable and getting help to animals who need it.
I think you also made the point that there are a number of states and municipalities, I think New York City is one, that also rely on these records to actually enforce their own local laws.
Yes,
so
thank you.
Does that continue to be a problem?
That continues to be a big problem. So a lot of localities and even states now have passed laws that condition who can sell, generally it's dogs and cats, within their town limits or state limits, based on what's in inspection reports, whether these facilities have been cited. And those laws, without access to this information, have become unenforceable.
So one of the really interesting things that you told me at the time, and I'm wondering if it's still true, was that a lot of the industry, or these three industries, a lot of players in them were not in favor of this action by the USDA. Is that still true?
Yeah, nothing has really changed on that point. There was massive uproar objecting to the deletion of information, and that included from the Association of Zoos and Aquariums, research organizations. And basically the idea was availability of this information is our public license to operate. It's how we assure the public that we're complying with the law. And so if you don't have anything to hide, you should have this information available.
Yeah, I guess it makes total sense that because these industry players are in competition with each other to some extent, and they kind of get painted with the brush of the ones who get caught. So
exactly.
The better players would want this information out there. That does make sense when I think about it. All right. So I think that we're kind of up to where you filed your lawsuit, which is just about when I interviewed you the last time. And you were actually a plaintiff here, right? You're not one of the lawyers. You're one of the plaintiffs.
Yes, I am one of the plaintiffs, along with PETA and a coalition of other organizations.
Tell us about the lawsuit, just the basic claims that you made, and then we'll talk a little bit about what has happened since you filed.
Yeah, so about 10 days after, I believe about 10 days, maybe a week or so after the documents were relieved from the USDA website, we filed suit, essentially asking that this information that had been available for so long and that was so important for advocacy work, for my own scholarship, for holding the government accountable, that access be restored to that information. And the core argument was that the eFOIA provisions that we talked about require that this information be made available. And the agency itself has said as much in writing repeatedly. And therefore, we're entitled to this information. It's really pretty straightforward.
Now, I know that things have shifted a bit because that was 2 years ago. And during the course of this suit, the agency has taken some actions which it asserts address your concerns. Can you tell us what those developments have been?
Yeah, so the agency has basically restored a tiny fraction of the information that was previously available. Most notably, they have ostensibly reposted inspection reports. The problem is that for the majority of facilities, the inspection reports are now posted with the identification of the regulated entity redacted. So you can you can go online and find an inspection report and see that, oh, this facility had a dead dog in a cage that nobody had noticed, but you don't know what facility it was. So it's become largely useless information. As to the other two categories of documents that we talked about, the research facility annual reports have been made available again, but most of them are missing the explanation pages, which are a really important component of the report. That's where the facility explains why it subjected animals to unmitigated pain or distress, and also why they departed from other minimum animal welfare standards. So those pages are missing. And then finally, as to the enforcement actions, the agency has announced that it will not restore access to those records.
And they've also, in addition to the stuff that they've restored, they've made certain statements about their future intentions going forward.
They did at the time state that they were evaluating what they were going to make available. At this point, in fact, I met with the head of USDA Animal Care last week and asked about their plans, and she unequivocally stated that they are done. They're not planning to make any changes or make any more information available, unless, of course, a judge orders them to.
And these redactions that they made, their basis was privacy concerns?
Yes, the purported basis is privacy. They have not really elaborated on that. It's a pretty outrageous assertion, given that privacy is intended to protect our personal lives. The things that we mentioned were previously redacted: signatures, social security numbers, not information about your operations of a business in a highly regulated field.
It just seems crazy. Like, what good is this information without knowing who it's about?
I agree.
Is the extent of privacy redactions defined anywhere in the regulations or in the statute even? Is that addressed anywhere? It just says privacy?
In the USDA regulations or in the FOIA regulations?
Yeah, actually, I guess either.
Yeah, so not really. It's really addressed in case law. There's a pretty robust body of case law that makes clear what it is and isn't supposed to cover. And business activities are not supposed to be covered. Even reputations of a business are not supposed to be covered. Embarrassment is not supposed to be covered. And yet we see USDA specifically citing potential embarrassment as a basis for privacy withholdings. So what they're doing is pretty inconsistent with the case law, but we haven't yet had the opportunity to make that argument on the merits.
So, as I mentioned at the last time we spoke, that suit had just been filed. I don't think there was even an answer yet. But since then, you've had a decision in the district court, and just very, very recently, a decision in the circuit. And things are really not resolved yet, but things have developed a lot. So let's talk about the district court decision. Can you tell us what was decided there?
Yeah. So basically, because the USDA had reposted some information, as I said, a tiny fraction of this information, it came into the court and said, "This is moot. We've made information available again. You should dismiss the case because it's not relevant anymore." And then they also argued that we hadn't adequately alleged that some of the information was subject to the eFOIA requirements. So the district court dismissed the case, which we then appealed to the DC Circuit, and we just very recently. Oh, sorry, you didn't ask me to talk about that one yet.
No, you can go ahead. Yeah.
Okay.
I mean, we don't need to spend too much time on the district court decisions. You just got the appellate decision.
So the DC Circuit fortunately saw through the agency's shenanigans and said, among other things, you can't post, quote, mutilated versions of documents and then claim that the case is mooted, and that our complaint had adequately alleged that we want access to the information, not just access to blacked out documents. So on that issue, remanded. And then also we had argued that even if there was a mootness issue, it fell within the exception for actions that are capable of repetition yet evading review. I don't know how much you want me to get into that, Marianne, but the bottom line is the DC Circuit said the agency hasn't met its burden of showing it's not going to just take these records down again, that it has in fact made them available for good.
Yeah, the whole, I mean, the whole argument that it's moot just seems like just an effort to totally waste everybody's time. I mean,
Absolutely.
You filed the suit and you said you wanted these records. After that, they redacted them and released them. And the court said, well, you didn't say you wanted them unredacted, so you have to file another lawsuit all over again. And it's just stupid.
Yeah, like, it's just delay.
Yeah, exactly. Just to in hopes that at some point you'll go away.
And we will not ever.
So you got a remand. I mean, we're not done, but you got a remand saying, all right, this isn't moot. The district court has to actually look at this case. Is that for everything? It isn't, is it? It's just different standards apply to different records.
Yeah. So basically, what happened is when we got that first district court decision, in addition to appealing the mootness finding, as to the documents that the court said that we hadn't adequately alleged were subject to the eFOIA requirements, which in an attempt to try and avoid delay, we went ahead and filed a new lawsuit on those issues, including the enforcement records and the explanation pages of the research facility annual reports. So we now have two suits in play. That second suit had actually, despite our attempts to avoid delay, been stayed pending the outcome of the D.C. Circuit case. So this D.C. Circuit decision now allows us to move forward on both of those lawsuits now.
I see. I had seen there was a second suit, and I couldn't figure out what it was about. So you actually split them. So this case is really just about the inspection reports now?
This one that was remanded, yes. Yeah.
All right, I get it. So next steps.
Next steps are that we push forward with the litigation, the two lawsuits. Now we can get to the merits on these issues, hopefully without further delay. I mean, I think once we get to the actual arguments as to why the privacy exemption is so far from covering this information, we'll hopefully get the information restored.
And that's the central issue in both of these lawsuits, is that they're defining privacy completely in this ridiculously broad way to actually cover all the relevant information.
That's the fundamental issue, and it's very tied up with this issue of whether or not they have to proactively disclose. So I would say for the enforcement records, where they're not posting anything at all, it also gets at this key question of what they're required to post online.
Oh, exactly. Yeah, of course. So what's the status of the second suit? I mean, what's its procedural status? You said it was stayed. Where was it when it was stayed?
In the district court before the same judge as a related case, and rather than there's been no decision other than to stay the case, which it is now no longer stayed in light of the new DC Circuit decision.
Okay, that's really helpful.
I know it's complicated.
Yeah, it's procedurally, I get lost in things, but we'll find our way out. As I recall, when we last spoke, there were a couple of other lawsuits. There was a lawsuit by HSUS pending, and a lawsuit by ALDF, the Animal Legal Defense Fund, pending on very, very related issues. Are those cases still floating around?
Yeah, so the ALDF case in particularly was essentially on the same issue of the eFOIA postings, and that there was an oral argument in the Ninth Circuit because the district court there said that these records were not subject to the eFOIA requirements, and we're waiting a decision from the Ninth Circuit. And then the HSUS case, and also there have been some other cases. We have PETA and I personally have another case, and the ASPCA has a case. So there's some cases on similar issues that also get at these privacy redactions, but they're about requests for the information. They're more of your standard FOIA requests rather than about what's on the website, if that makes sense.
Yeah, no, it does.
Yeah.
And so there's a lot to keep an eye on here, a lot going on. We'll have to be talking to you 2 years from now.
I hope it's sooner.
See if something happened. But we do have another update. It's kind of extraordinary. We have another update on another topic that you talked about on this was on episode 15 way back about a research. I mean, this is a subject that you've been doing scholarly work on for a very long time regarding the licensing practices of the USDA under the Animal Welfare Act. And I, again, to our listeners, I strongly suggest that if this is a topic that you're interested in, go back and listen to that episode before you listen to the update. But in case people don't, can you just kind of summarize the issue for us before we talk about the latest developments in this area?
Yes, indeed. So the Animal Welfare Act requires regulated entities to have a license to operate, and it says that no license shall be issued until you've demonstrated compliance with the minimum animal welfare standards. And despite this mandate, the USDA for years, for decades, has brazenly been automatically renewing licenses in the face of blatant chronic violations. Their stated policy is to automatically renew licenses. And this has been a big problem because it means animals are suffering on the USDA's watch, and the USDA is facilitating this. So it's a topic that, as Marianne said, I've tackled in scholarship, and PETA has also filed a series of lawsuits challenging this policy starting about 6.5 years ago.
And so we've actually recently seen it's as if these two issues, they think that these two issues have nothing to do with each other, whether they violated the Animal Welfare Act and whether they should continue to have a license under the Animal Welfare Act, as if it's unimaginable that those issues are related in any way.
Right.
It's just bizarre. But we have seen some progress. I don't know whether this is good or bad because I don't understand enough about the details to know whether what they're proposing now.
Yeah,
it's probably, my guess is that it's mixed, but I'm going to rely on you to tell me how to feel about it. So tell us about it. So the USDA has just made a proposal to resolve this issue, and tell us about what they're saying.
Yeah, so the USDA has just come out with a proposed rule, which on its face would get rid of automatic license renewal. It's a, I believe, 48-page Federal Register notice. So there's quite a lot in there. But the bottom line is that they're proposing to change the approach so that animal welfare licenses would be issued for 3 years. They're currently issued for 1 year, after which you need to get a new license, and issuance of that new license will be conditioned on a demonstration of compliance with the Animal Welfare Act standards.
Well, that sounds like all good news, is it?
I wish it were that easy. I mean, on the one hand, they are saying they're going to condition license issuance on compliance. There's some concerns. One big one is that they have inserted a right to a hearing. Basically, they've basically said, if you don't get your license issued, you can seek a hearing. You can get a full trial type on the record hearing. And that is extremely concerning to me, because not just because there's no legal requirement for that, there's no basis in the law for doing that, but it will just grind everything to a halt. We've already had a massive problem with the USDA's reliance on outdated trial type hearing processes, which the agency's own administrative law judges have complained about. The Inspector General raised concerns about a quarter of a century ago. And this is just introducing all sorts of additional hearings for these overworked ALJs to have to deal with. And it means that animals will continue to suffer. In addition, we have concerns because the agency has stopped citing for a lot of violations that used to be cited. So we're worried they're going to rely on inspection reports that make it seem like everything's fine and dandy when it isn't. I would say those are the core concerns. There are a lot more of smaller ones, but those are the biggies.
So this hearing proposal, I'm kind of confused. Like, what would the hearing be about? I mean, if they were found to have violated the Animal Welfare Act by the USDA, why does the USDA have to have a hearing to find out whether that's true?
It frankly doesn't make sense, especially when you consider the fact that there's already a procedure in place for you to appeal within the agency.
I assume there's some process attached to the violation itself.
Yes. Anybody can appeal that, and it's not finalized until you've had an opportunity to appeal that. So there's already a process in place for that. So there is nothing, Constitutional Due Process, Administrative Procedure Act, Animal Welfare Act, nothing says you're entitled to all this excessive process. And it's really just trying, as far as I can tell, trying to make things very easy for the animal exploiters.
Yeah, it just seems completely redundant. I mean, I assume from what you're saying that the really big problem is that the termination of the license would be suspended or your inability to renew your license would somehow be suspended until this hearing was held and decided?
Right. So if I have a license and I'm coming up for renewal and I submit my application and the USDA says, nope, you're in violation, you can't renew, and I say, fine, I'm appealing, I get to continue doing business as usual until that hearing happens and I get a final decision.
Yeah, that's pretty crazy.
So it prolongs animal suffering, frankly.
Yeah. And really, as you pointed out, just causes a lot of bureaucratic snafus just for apparently just for a hearing that's essentially redundant for people who've already found to be in violation.
A tremendous amount of resources, taxpayer resources and otherwise.
Boy, well, it's good news for a second until you look at it more closely.
Yeah, I mean, so what we're encouraging, the agency is taking comments on its proposal till May 21st, and we're really encouraging people to take the time, even just a few minutes, to submit comments and say, this is a good idea, but you can't provide these hearings. You need to do it without the hearings. And then also you need to really determine compliance based on the full record before the agency, not just a cursory pre-announced inspection. You really need to attend to what's really going on at the facility.
So I just, before I let you go, I'd just like to ask, this is something that you've alluded to a few times, but I'd just like to ask kind of the broader question of the culture at the USDA under the Trump administration. The administration had just come in when we last spoke about this, and actually, as you pointed out at the time, some of these issues were already in play before the Trump administration came in. So it's not totally just a change in administration, but I am curious about how have you seen the culture shift at the agency under this administration? Yeah,
so I think you got it right. Basically, the Animal Welfare Act is a statute that has never, ever been adequately enforced. But under the current administration, we have reached a new low. We have seen an unprecedented decline in enforcement actions. We've seen an unprecedented decline in citations. We see basically an agency that has decided that its job is not to protect animals, but to protect businesses that profit off of animals, and to do everything they can to protect those businesses, not just from enforcement action, but even things like public scrutiny.
Yeah, I guess that's not surprising, but it is depressing to hear. This is kind of a big question. I don't expect you to answer it in full, but just basically, the Animal Welfare Act, even if it were perfectly enforced, would not solve every problem in the world for animals, that's for sure. But what would proper enforcement look like?
It's hard to imagine. Proper enforcement would be worlds apart from what we see now. You would not see facilities where animals are deprived of veterinary care, are beaten to perform in circuses, and yet given a free pass for what they do. There's still minimal standards. The animal welfare standards are by definition minimal, but animals aren't even getting that right now, and it would be a start.
Yeah, no, I think it is important for people to understand, which I imagine most of our listeners do, that they are very minimal standards, but minimal standards are better than none at all.
Right. Yeah.
Well, thank you for enlightening us. Thank you for all of the work you're doing on behalf of these animals. It's an ongoing saga, and I hope you'll come back to share new developments as they occur.
Yes. And can I do a plug for what I think we really need to get us closer towards a vision of proper enforcement of the Animal Welfare Act? I think what's direly needed, and Marianne, you wrote something on this issue years ago, is a citizen suit provision. We have one in the Endangered Species Act. We have one in every federal major environmental statute. And yet our most important animal protection statute lacks one. And I think that would go a long way towards something approximating better enforcement.
Yeah, I totally agree with you. And this is an issue that I have like thought about, and I did write something about it a long time ago. It's not an issue like so many things. It's kind of something I gave up on thinking about for a while, but you never, like, I feel like we're at a time of enormous cultural shift and possible enormous shifts in our ideas about government and possibly our ideas about animals. So who knows? Some of these things that we thought about 10 years ago, which we thought would never happen, maybe the moment is coming. Yes, I have to hold out hope. Well, thank you for hoping, and thank you for enlightening us about all these incredibly depressing things, and and for striking that balance between despair and hope. I try. Thanks, Marianne. Thanks so much for joining us on the Animal Law Podcast. We'll be back next month with a new show. Thanks so much to Delcy Winders for taking the time to explain all of these issues relating to the Animal Welfare Act to us. Thank you to Michael Harron and John Frusciante for their help in producing the podcast. And in the meantime, if you like what you hear here, please subscribe. That helps us out so much. You can subscribe on Apple Podcasts, or you can subscribe on your favorite podcatcher. Consider leaving us a good review. You can do that also on Apple Podcasts. And if you're able, please consider making a tax-deductible donation at ourhenhouse.org. And thanks so much for tuning in.